Hi, my name is Gloria Jean Warren, and I'm speaking for my friend Barbara Rejon. Barbara Rejon lives in Congress, Arizona. Barbara Rejon of Congress, Arizona, has been a victim of corruption in the Congress Elementary School District. She has had government corruption where people in the government, from everybody from the Attorney General's office on down, has not responded to her complaints. Okay. All right, so I'm reading Barbara Rejon's letter to the legislature. Dear Mr. Windsor, this is written on August 3rd, 2012. I am writing to you in the hopes of correcting a great wrong, the power given to school districts and their governing boards. The power they have to destroy lives is incomprehensible. I know because they have pretty much destroyed mine. They have been allowed to lie, cheat, steal taxpayer money by using it to sue parents, file a frivolous and fictitious lawsuit, destroy records, retaliate against those who try to speak out against this. Elizabeth Hill, formerly of the Ombudsman Citizen Aid Office, would include in her letters to the principal superintendent of the district. According to the ARS 41-1376.01D, it is contrary to the public policy of this state for any agency or any individual acting for an agency to take any adverse action against an individual in retaliation because the individual cooperated with or provided information to the Ombudsman Citizen Aid or the Ombudsman Citizen Aid staff. Yet in the complaint filed by the district, they included a letter from Pat Shanahan, also formerly of the Ombudsman Citizen Aid, as evidence of the harassment they were claiming. Obviously, the entire lawsuit was in retaliation for us filing complaints. Providing information to the Ombudsman Office and other agencies we thought would help us requesting agendas, minutes, and records on our children. Why else would the district ask, excerpt from this complaint was for an injunction permanently restraining and enjoining the defendants and each of them from filing any additional claims or lawsuits in or before any court, administrative agency, or other forum whatsoever against plaintiff or any of its agents, servants, offices, employees without first obtaining leave of this court. Their request leads me to believe that they not only knew that they were doing was wrong, but they had no intentions of stopping. In October of 2007, she found out her daughter was seeing a counselor at the school. She wrote to Mrs. Wyeth, the former principal superintendent, asking for information such as counselor name, etc. No answer. She wrote 2 more times over a 16-month period asking for this information. Finally, in March of 2009, she went into the school in person to ask for this information. And Mrs. Wyeth angrily scribbled on a Post-it note the name and phone number of the Yavapai County Educational Service Agency, and as she was thrusting it towards her, told her the district did not have the information she requested and to go call them. She couldn't tell her that 16 months ago. Her 3 letters were included in the lawsuit as evidence of her harassment, though they were labeled as public records request. In 2009, when her daughter was humiliated in front of all of her schoolmates, when Mrs. Wyeth, former principal superintendent, announced rather loudly that her daughter could only have a peanut butter and jelly sandwich because her parents hadn't paid for her lunches. She was furious because she had always kept very good track of the payments. I asked for a copy of the lunch account records and found that she had been charged for 9 lunches she did not have there. She also noticed a $50 deduction to her account that she had not explained. I wrote to the school, no answer. Later, I read in their audit report that they were tagged for not depositing checks for the lunch accounts in a timely manner, among other things. My letters regarding my daughter's lunch account were included as exhibits in the complaint. They were 2 labeled public records request. I was afraid to ask for anything on my daughter's lunch records in 2010 because of the lawsuit. I was afraid to ask for anything. These are only two examples of the treatment that I had to endure at this school. It has been a long, frustrating road and very much like milking a bull just to get even the most basic information from them. Information I used to think was right of any parent to have, information on their own child. In 2011, after the lawsuit was finally over, I asked for my daughter's 2010 lunch records. They were destroyed. I was told by the new principal that the district changed their computer program and all previous records are no longer available. Yet, according to the ASLAPR, Arizona State Legislature of Public Records, records retention schedule, those records are to be kept 3 years after the fiscal year created. Not only should they have had the 2010 account log, they should have had 2009 as well. That was included in the lawsuit. How convenient for them for the records to no longer exist, and they do not have to answer my question regarding $50 and deductions from my daughter's lunch account. Besides the few times I've asked for copies for agendas, minutes, I had only asked for records and information on my child. Had the district continued to post the agendas and minutes online, as they told the Ombudsman's office that they would do in 2007, that the only reason that they did that was to appease the Ombudsman's office so that they weren't being monitored anymore. I wouldn't have had to ask for those items anymore. They did not start posting them full-time online until 2009, a year and a half after the Ombudsman's office said that they had to. A year and a half of the district now being able to use my request for these items against me. Essentially, I was sued for asking for records and information on my own child. The former principal superintendent labeled them public records. The board brought it and voted it to sue us, claiming they had reviewed all evidence. If they reviewed it, how could they not see the evidence produced was fabricated? And if they did see that it was, how could such unethical behavior be excused and even protected by our very own laws? I believe the lawsuit was filed not only as retaliation, but as a way to shut us down and shut us up, because while the lawsuit was pending, no agency would look at any complaints we sent in. After the lawsuit, when we were contacted, those same agencies, we were told the statute of limitations had run out and it was too late now. Even though the district technically lost the case in court, they ultimately won in the real world, as they were able to stop us, tarnish our reputations, and kill, at least in me, my belief in the system, the laws in the state, and the Constitution of the United States. What's wrong with our system when a judge does not even notice that what is claimed in the complaint and what is supplied as evidence does not even match? How do they pass judgment if they obviously do not read the case documentation? Laws written regarding these abuses have no one to enforce them. You only have rights only if you have money to hire an attorney to enforce them. Criminals have more rights and more access to legal help than parents and non-criminals. Attorneys do not have to abide by the rules of professional conduct. Gun rights are more protected than parental rights. School districts and their boards have some kind of diplomatic immunity that allows them to legally destroy people's lives without fear of penalty. And Barbara also wants to see some type of legislation so the Board of Supervisors of the county of a school district has direct control over that school district. Thank you.